Okay, well, good evening, everybody, and welcome to our latest educational session, this time regarding trusts. I'm Mike Hebron, the Chief Operating Officer with Level Financial Advisors. I want to welcome everybody tonight. And I'd like to introduce our speaker tonight. But before I do that, let's talk for a couple of minutes about some of the parameters. We want to keep this interactive. So as the presentation is going on, if you have questions, there is a Q&A function at the bottom of your screen. You can go ahead and type your question in there. And at an opportune moment, I will jump in and interrupt Judy during the presentation to ask that question if it's appropriate. The other thing we want to mention too is that if you want to do a one-on-one question with Judy, we're opening up our text line for that. So you can text the word trust, just simply send that message, trust, to 716-727-5047. And if you send that there, we'll put you in touch with Judy and she'll reach out to you and you can ask her that question. We'll have that information as well at the end of the presentation so that you can write it down if you didn't grab it quickly right now. So let me introduce Judy Wagner. Judy is with estate planning attorney and partner with Harris Beach LLC Attorneys at Law. And Judy is as an estate planning lawyer. She counsels individuals and families on wealth planning that includes appreciation of current and future financial and personal needs. She's been with Harris Beach since 2006. Judy, aside from being an awesome person, has extensive legal experience with the most effective tools for the transfer of assets, such as wills and trusts, including asset protection trusts, irrevocable and revocable trusts, and prenuptial or post-nuptial agreements. So without further ado, I'm going to hand it over to Judy, and just want to remind everybody, if you have questions, use that Q&A function and we'll make sure we get them to Judy. And so, Judy, I'm going to turn off my video and over to you.
Thank you, Mike. Thank you, everyone, for tuning in this evening. I hope you're all relaxed and comfortable on the couch with a glass of wine while we talk about trust tonight. But I would like to thank Level Financial for having me tonight for this program. There's so much important information in this area. And I've worked closely with Level Financial for a long time, and ever since Richard Schroeder was at Level Financial, and now he's off and retired and enjoying his retirement. But Roseanne and Steve and Paul and Elise work very closely with them a lot on a lot of clients. So I'd like to thank you all for being here tonight. And I'm going to jump right in because we have a lot of material to get through tonight. As Mike said, you can text trust to the number that will be that'll be provided again later in the program if you didn't catch it. So get your pen and paper ready. But there's all kinds of ways for you to get in touch with me or to get in touch with the folks at Level Financial if you have questions. But I love doing this work. I've been an estate and trust attorney for 20-something years, but this is all I do. And my firm is great because it allows me to be able to just do this type of work and depend on someone else for the corporate work or the real estate work or whatever happens to be an issue. So it's nice that I am able to just do the estate and trust and the elder law work. So I'm going to, I guess, shut my camera off, and then we're going to move ahead with the nuts and bolts of our program tonight.
Yeah, I'll just make a quick note too about the disclosures too, if we can. This will be part of the presentation that we send out, but the following presentation is intended for general information purposes only. So no portion of the presentation serves as the receipt of or as a substitute for personalized investment advice from Level or any other investment professional. Please see additional important disclosures at the end of the presentation. We will actually email that out to you so you have it. So Judy, now that we got the lawyer speak out of the way, I will once again mute my microphone and you can take over.
And likewise, none of this is construed as legal advice. It is general information. So the same disclosure goes to me, or goes for me as well. So let's dive right in. Just starting with the basics, what is a trust? It's a tool in our arsenal of estate planning. So along with your will, your power of attorney, your healthcare proxy, all of those important basic things that you should have, a trust is another one of those types of things that is that we have in our toolbox to accomplish whatever your goals are with your life and with your family. So what it actually is an entity that's created by a document. So we actually have a piece of paper, an agreement that you create, or that we create together, that that is going to have all of the rules for how your trust is going to operate. So for basics, your trustee, that's although the trust is an agreement, you have to have a human, a trustee that is running the that is quarterbacking things for you or steering the ship. Trust property, so you have to have some assets in the trust for it to be an actual trust. Those are your assets that are in it, maybe property, maybe cash. We're going to talk about that a little bit later. Your document, your agreement with all your rules and regulations in it, and your beneficiaries, the people who are entitled to the either the income or the principal from the trust. So the trust document itself specifies all the rules and all of the mechanics of the trust. So it's going to say what the trustee is allowed to do, what they aren't allowed to do, what the rules are for distribution, whether or not income can be distributed, whether principal can be distributed, and if it can, what are the rules? How do you want those distributions to be handled? These trusts are beneficial for estates of any size, not just large ones. A lot of people think that that trusts are just for the super wealthy, and that's not true at all. I pride myself in being a lawyer that handles mostly middle class folks. I handle I handle high wealth people as well. But my dad worked at General Motors. My mom was a housewife, and this is the kind of trust. There are trusts that I do frequently for families just like my own, that accomplish big things for those families, for families that worked hard for the wealth that they have accumulated. And even if it's not millions and millions and millions of dollars, there are important, the trusts play an important role in their lives as well. How is a trust created? A lot of people come into my office and say, I just don't understand this. What is a trust? And it is, it's created by this legal document, the trust agreement. You are creating the trust. As the creator, you could also be called the grantor or the settler or the trustor, depending on what type of trust we're creating. But it all means the same thing. You're the creator of the trust is typically called the grantor, and that agreement is providing instructions for management of the trust assets. So whatever is in the trust agreement says how the assets are going to be invested, when they're going to be distributed, and when the trust ends. And then when it ends, how is the trust distributed out to the beneficiaries? The trust agreement really is your roadmap of how things are going to be handled along the way. And these are all legal requirements. So the whatever assets are in the trust, the trust governs the assets. So how is the trust actually funded? How does this actually work? A trust is not a real trust until assets are moved into it. I have a lot of people that come into my office and say, "Oh yeah, I have a trust." They bring in their trust agreement and show it to me, and I say, my very next question is what is in the trust? And if they scratch their head and say, I don't know, and we can't figure it out, maybe there's nothing in the trust. And this happens frequently because, years ago, it was a sexy thing for people to, for advisors to buy a steak dinner at Salvatore's, and you left with a binder with a trust in it. But unless you took the next step and funded that trust, then you don't really have a trust. Other times I have people think that all of their assets are, we're discussing this, if they think maybe all of the assets are going to go into the trust, and that's frequently not the case. But the trust is not funded until the title of ownership is actually transferred from the individual's name into the name of the trust. So think about it in terms of a house. Let's use a simple example, a house. If it's deeded to you and your spouse as individuals, it's not in the trust until we do a new deed and transfer that house into the Judy Wagner Irrevocable Trust, or the Judy Wagner Revocable Trust. At that point, when that ownership is changed into the trust, now we have a trust asset. And that could be done with all kinds of different accounts. Quite frequently when we're doing trusts, we'll move over brokerage accounts, and we would create a trust account, a brokerage trust account in the name of the trust. We can change ownership of an annuity to the trust. We can assign personal property to the trust. If you have a business, we will sometimes assign limited liability company membership interests into a trust. I've done bonds before. We frequently will change ownership of life insurance into a trust because it's good for asset protection, that we'll talk about a little bit later. But not only does that protect the cash value of that policy, but it also protects the death benefit. But part of the analysis of what we do when we're going through this exercise, and when I'm working with clients, is for your team to take a look at everything and do an analysis and decide what kind of, if a trust is right for you, and if so, what kind. Take a look at your financial details and decide what assets are appropriate to go into the trust. And your team, myself as the attorney, your financial advisor, maybe your tax professional is involved. We're gonna help you decide what the right thing is to be transferred into what assets to be transferred into the trust.
So hey, Judy, I have a quick question that came in while you were explaining all that. So
Alrighty.
This question says, can an asset, maybe a brokerage or an IRA, for example, have a beneficiary that is, in this example, a trustee for John Doe Living Trust dated, whatever date, May 14th, 2020, whatever date. So can an asset have a beneficiary that is a trustee of a living trust?
Yes, absolutely. So, one way that we fund trusts is by the ownership change that we just talked about. But another way that a trust is funded is through a beneficiary designation. And that's part of crossing the T's and dotting the I's when we're establishing and funding a trust. Because if you have a brokerage account that you want to flow through the trust, or if you have a life insurance policy that you want to flow through the trust, it accomplishes the same thing by designating the trust as the beneficiary, because it's all going to flow together into the trust and then be governed by the terms of the trust as they have been established. So that's something that we do quite frequently, is assign the trust as the beneficiary of different types of things. So who manages the trust is next. Like I said earlier, we actually need a human to manage the trust, right? We have the agreement, but we actually need a person that is going to be the captain of the ship. So this person, who is called the trustee, is managing the assets in the trust. The rules for how the trustee manages those assets are contained in the trust agreement. In most cases, the trustee, unless there are specific details in the trust, the trustee is responsible under what in New York is called the prudent investor standard. And what that means is that that trustee is taking care of the assets in the trust as if they were their own. So if that standard of care that is set out by New York State under the prudent investor standard, that's what the trustee is responsible for. It's also known as fiduciary duty. They have that level of care to watch out for the assets in the trust, and so for people also are concerned that the trustee has access to the assets in the trust for their own use, and that's not true. The trust assets are not their own. They are acting as a fiduciary, so they're acting as watching out for those assets. Same thing that like if you have someone named as your power of attorney or someone named as your executor, that person is watching out for your assets, but those assets are not their own. They will anything that is in the trust is not considered to be, if your trustee is applying for a mortgage or something like that, then a lot of people are concerned. Our parents are concerned that they're appointing children as the trustees, and then and then if they go to do a mortgage application, that the assets in the trust are going to affect them in some respect, and that's not the case. Trustees are only fiduciaries for a trust, and the duties of the actual duties of the trustee can vary. It all depends, and I'm going to say that a lot tonight. It depends. What the trustee's duties are depend on the type of trust that we're establishing. It could include, in I guess in most cases, it's going to include receiving assets and possibly managing those assets if they're liquid investments, if they're investments that the trustee has to look out for the appropriateness of those investments, collecting income as it comes in some cases, but not all. The trustee is responsible for doing an accounting and providing that to beneficiaries, any tax filings that are necessary. If the trust calls for the distribution of income, then the trustee is responsible for making sure that that income gets passed out to the beneficiaries. And as we talked about, the trustee cannot use the trust funds for their own personal use. And who you choose as your trustee is an important decision, and it's a very personal decision. People, we have this conversation a lot because sometimes, depending on the type of trust that you create, you can be your own trustee, but sometimes you cannot. So choosing who acts as your trustee is sometimes a very important decision, and it might have to do with whether maybe one of your children is a little bit better with finances than others. If you're coming, if you have a blended family, then maybe you're choosing a trustee from one of the husband's children and one of the wife's children so that they can work together. But choosing who is going to be your trustee and how if there's more than one, how those trustees will interact together are important decisions, and very personal ones. So these are things that the professionals will help you work through to make the best decisions.
Judy, we have another question.
Okay.
This question says, is a trust needed for a husband and wife who will leave the remaining spouse everything? And in this example, they say our two sons would then be the final beneficiaries for the last remaining parent.
Well, there's lots of different reasons. I guess it would depend on the reasons why you were creating the trust. If we're doing an irrevocable trust for asset protection, and those assets would would stay in the trust until both spouses passed, and then you have one of the children acting as the trustee, then that's one reason to do a trust. But another reason is, and we'll talk about it a little bit later on, but doing a revocable trust to simplify estate administration and to avoid probate, then that's another reason to leave assets in trust. But typically in that circumstance, the grantors are the trustees, and then at the end of both the grantors' lives, like one of the children would step in as a trustee and distribute the trust, finally distribute the trust to the beneficiaries. I hope I answered your question, but if I didn't, you can.
Yeah, I'll encourage them to use
can,
the text line there and
yeah,
send a text, and then you can reach out and speak more directly about their actual situation.
Right.
Perfect.
Okay. Okay, so trust administration is next. How is the trust administered? So this is the maintenance part of this. And this is always a big question that I get. Once we create a trust and we get it funded, is there annual maintenance? Do I still need you after the trust is created? What happens next? And that all, again, I'm going to say this a lot tonight, it depends. In a lot of cases, once the trust is created and funded, you don't need me anymore, because there isn't much to do unless there are active things going on with the trust. There isn't anything that you need me for. So it's just a matter of the trust going on autopilot until it's time for it's time for distribution. So sometimes there, it's not a heavy lift for the trustee. Parents are concerned about appointing children as trustees, because it's going to be a lot of it's going to be a lot of work for them. They're concerned about their kids working and being busy, but a lot of times it's not a heavy lift. But it just depends on the type of trust it is. But some of the duties of a trustee include, if there are bills to pay, the trustee would pay those bills. Developing investment strategies and working with the financial advisors, overseeing those investments, maintaining records, always important, whatever tax reporting is necessary, and making distributions to beneficiaries. So again, it just depends on the type of trust that you're creating, and what administration is after everything is set up. Main types of trusts. So there's two main areas of trust. So we're going to step up and do a 30,000 foot level here for now, and then we're going to delve in a little bit deeper into the detail. But two main trusts, types that you create during your lifetime. That's a living trust, or an inter vivos trust, we call it, established by a living person during their lifetime. Can be revocable or can be irrevocable. And the second main type of trust is a testamentary trust. And what that means is that you've established a trust under your last will and testament, and that trust is going to be established or is going to come into being at the time of that person's death. And for an easy example of this is that you may have done your will when your kids were little and created a minor's trust for those children. And so that was set up so that if you died, the money that from your estate would go into a trust for your minor children to be handled for them on their behalf until they reached adulthood. And then the money would be distributed out to them. So that's a simple example of a testamentary trust. So let's dive in a little bit deeper. Revocable trusts are created during lifetime, but the grantor is retaining power to make any kinds of changes to the trust that they want. Revocable is just like it sounds. You can revoke it, you can change it, you can do anything to a revocable trust that you want. Grantors are in complete control of this type of a trust, including all of the assets that are in the trust. They have access to all of the income, all of the principal, and but the trust is designed to name beneficiaries at the grantor's death. The good part about this type of a trust is that the trust lives on past the grantor's lifetime. This type of a trust we very often will use to avoid probate and keep everyone out of surrogate's court as much as we possibly can. Surrogate's court is a train wreck right now. It has been ever since COVID started, just like a lot of things in our lives. But the complexity of surrogate's court and the length of time that you get stuck there, and the cost of everything at a very difficult time in people's lives when there's so much emotion involved. Avoiding probate has become a very significant, important planning tool. So I never used to be one of those lawyers that said, you really should do a revocable trust or do some type of a trust so that we can avoid probate, because probate wasn't really that difficult of a thing. It wasn't. It was not very time consuming, and it wasn't that big of a deal. But currently in surrogate's court, they have a backlog of 2,000 estates right now. They will not let us even ask for a status report on an estate that we've submitted for probate until it's been there for 90 days. So it's not a quick process anymore. And so saying that this trust lives on past the grantor's life, allowing the assets in the trust to be distributed out to the beneficiaries without having to go through the surrogate court process is a very important planning tool, and in this stage of our life and our culture that we're trying to get used to. As the PowerPoint says, the assets are available to creditors. This is not an asset protection trust. Because you have access to it, the grantor has complete control over it, complete access. This is not an asset protection trust. This is not for long-term care planning purposes. This is not what we do. But for this type of a trust, this is your, if you have out-of-state property. I have clients a lot of times that will have a house in New York and a condo in Florida. If you don't have that property in Florida in a trust, then you're doing, or both properties in a trust, we're doing probate proceedings not only in one state, but in two. So doing a revocable trust if you have out-of-state property is very good planning, very, very good forward planning. If you have a small family circle, if you anticipate having a difficult probate proceeding, when you have a very small family circle, sometimes probate can be very complicated, and those type of details are for a presentation for another day. But if you anticipate that you're going to have problems with probate, like if you have a child that you think might contest the estate or that sort of thing, if you're just disinheriting a child, these are all reasons to do your best to avoid probate. With the revocable trust, all of the income that is created under the trust is taxed to the grantor on the personal income tax return. We do not get a separate tax identification number for a revocable trust. Everything is assigned under the grantor's own Social Security number, making taxation very simple. You don't lose any of your tax exemptions or anything like that. Everything is very simple. So let's jump on to trusts that are a little bit more complicated than revocable trusts. There's all kinds of different types of irrevocable trusts, but the basic overall concept is that an irrevocable trust, you've given up the right to the principal of the trust, and that the trust cannot be altered or amended or terminated by the grantor alone directly. We're going to qualify that statement in a second. I'll explain, what we do is we have found different ways to get around that rule, to give the grantor as much control over the assets as possible, because life changes. We all know that everyone is just living their lives and life changes, and you have to have some control over these things. or it's not worth doing. So, and I wouldn't do it either. I don't do anything that I cannot undo. And this is one of those situations where I want to make sure that if we create an irrevocable trust for you and something changes, we need to be able to undo it. This is the type of trust that is designed for asset protection from creditors. So if you are doing your retirement planning and long-term care planning is a concern for you, which it should very well be with nursing homes costing $16,000 a month, this is the type of trust that we will talk about. It is designed for the grantor to maintain certain types of control. The examples that I've given, you have the ability to change who the trustee is. This is the type of trust that you can't act as your own trustee, so you do have to choose a trustee for this type of a trust. And I want you to be able to change that person if you need to. You also have the right. We maintain the right to you for you to change who your beneficiaries are. Life changes. People get bent out of shape about things. So I want you to be able to change your mind. Or if you decide that your children are very well taken care of and you want to set up a trust for your grandchildren in your irrevocable trust, we can make those changes to realign it so that the trust is going to go to grandchildren instead of children, or any any type of those things. These types of trusts are also used for tax planning purposes because it is an irrevocable trust. Tax planning trusts that we use for tax planning that are irrevocable are a little bit different because they have to be locked up a little bit tighter. But we have those. The trusts serve a very important purpose when we have people that have larger estates that we anticipate that they will have estate tax liability. So there's lots of good things that we can do with trusts for tax planning. It seems sort of counterintuitive, but in New York, you can revoke an irrevocable trust with the consent of the trustee and the beneficiaries. There are some very specific things that go along with these types of rules, but the general rule is that can be done. And that's part of the reason why I want to give you the ability to change the trustee and the beneficiaries, because if your trustee doesn't think it's a good idea for you to revoke this trust and take the assets back from the trust, then you have the right, the grantor has the right to change who the trustee is, so that we can put people on the trust that are going to cooperate. And I've had this happen for a couple of times for various reasons. I did one recently where we had 6 beneficiaries. There were 6 children involved in this particular trust. And we needed to undo it for a specific purpose, and we changed the beneficiary from all 6 children to only 1, so that it was just easier as far as administration is concerned. We only needed 1 signature instead of the consents traveling around the country to get all 6 of them. Everyone was in agreement, but it just made it easier administratively for us. For asset protection trust, before we move away from irrevocable trust, just quickly, every different kind of trust has different tax reporting situation, but especially for the long-term care, for the asset protection trusts, these have very favorable tax treatment. We use these very often to move real property, move a house into an asset protection trust. Or if you've got a brokerage account, and the folks at Level Financial have done an outstanding job, and there's money there that you think you're never going to need, we may carve out a section, a percentage, or maybe half of that brokerage account, and transfer it over to that irrevocable trust to start the 5-year look back period, so that the assets in that brokerage account will be protected. But the important tax part of this is that appreciated assets in that brokerage account can be moved over into this type of a irrevocable grantor trust without any tax ramifications. So you do not have to recognize the tax on the gain that has accumulated on those assets. when you're transferring assets into this type of a trust. I have a good example. I have actually a client that I did a trust for years ago that just came back for some changes, but the husband worked for National Fuel, and he had gotten, they had $500,000, and they have $500,000 in National Fuel stock with very little cost basis in it. And they didn't really need, the husband passed, the wife now lives off of the dividends from the stock because the trust gives her the right to the income. But we didn't have to pay the tax on all of the gain on that stock when we moved it into the trust. And when the wife passes and this trust is distributed, the stock gets a step up in tax basis. So now they have completely escaped all of the gain on that stock, and it is now distributed to the beneficiaries without any capital gain. So all kinds of we don't have a ton of time today to talk about all of these details, but sitting down with the folks at Level Financial and myself so that we can go over your particular situation and we can help you with all of these different nuances. Next up is testamentary trusts, or trusts under a will. This type of a trust is created actually in your last will and testament. So it's not a separate document. It is actually your last will and testament, and then we're including in that will a trust. And these are done for all kinds of different purposes, but you should know that this requires using this type of a trust requires probate, because surrogate's court is needed to process the will, have the executor appointed, and then formally have the trustee appointed for this type of a trust. Many different types. Minors trusts we talked about already for those kids who are minors. A spendthrift trust we will very often use in a will. That's a trust where if you have a child that has, or a beneficiary that has financial challenges, and their money can't flow out to them right away, otherwise creditors are may be after it. That's what a spendthrift trust is for. So it allows people to not have to disinherit that child, but keep their share in trust so that it's not lost to creditors. This type of trust also, we have, I have people that will come in and say, my one child just is not good with money. I need to create a stream of income for them. So I want it specified in the trust that I want $1,000 a month to be just distributed out to this child, and so that they can use it as a stream of income. We can be creative to suit whatever needs there happens to be. Trusts are great. We can do most anything to fit them into your puzzle pieces. The credit shelter trust that's listed there is one of our tax shelter trusts, and that's necessary. We use that when we have individuals that we are anticipating that they will have a estate tax liability. So in New York State, that is an estate of $6 million or more. So even if you have a married couple with combined assets of $6 million or more, including the death benefit of life insurance, then we want to talk about a credit shelter or a disclaimer trust in your will, so that we can make sure that we can avoid as much as we can any estate tax liability, either on the New York State level or on the federal level. The federal numbers are quite a bit higher. They are 12 million currently. We've been watching to see if those numbers change with this new administration. They haven't so far, but you just never know. So these are things that we keep an eye on. A generation skipping trust is a trust that we create when my client says to me, my kids really don't need the money from this trust, so we're going to skip over my children's generation and leave assets to my grandchildren. And there's lots of different tax ramifications that go along with that. So those are things that we can talk about, but that's another just example of a trust under a will. In a supplemental needs trust, is a disability trust. And actually, I'll skip over to the next slide to talk about that because I want to talk about that in a little bit more detail. A disability trust is also known as a supplemental needs trust or a special needs trust. And this is the type of trust that that individuals with disabilities are allowed to have and still be able to maintain their any government benefits that they have. So if you have a disabled beneficiary that gets Medicaid or gets SSI or SSD, and that would benefit from their assets going into a trust, then the supplemental needs trust is the way to go for that beneficiary. That type of a trust is designed so that we don't want parents to have to disinherit their children just because they are disabled, and this is what allows this is what allows that to happen. How it works is that assets that go into this type of a trust have to be distributed what we call in kind. I have a client that I've taken care of for 25 years that doesn't have any family, and I'm the trustee of his supplemental needs trust, and I can buy anything for him with the exception of clothing or with the exception of food rather, or pay his rent from his supplemental needs trust. So he actually just moved. So I bought him a couple of new recliners. But how it works is that I can't give him $1,000 to go buy recliners. He went to the store, picked out what he wanted, and then I have to, as the trustee, I have to pay Raymore and Flanagan for the chairs. I cannot give him cash. But by doing that, it allows me to enhance his quality of life by using the assets in the trust and not interfere with his with his benefits. So I buy him, we just did an Amazon order. I buy him his cleaning products. We just bought him some new curtains for the new apartment, a new kitchen table. I bought him some new sheets. Anything that is not food or rent, I can buy with the money from the trust. So this is huge for people that have disabilities, and really changes their lives. So a couple of different kinds of drilling down a little bit more, a couple different types of supplemental needs trusts that we have different categories. The first party supplemental needs trust is the trust that is funded with the disabled individual's own money. So when I said that these types of trusts change people's lives, Medicaid only allows people to have about $900 a month in income. So if I have a client that has Social Security benefits that are $1,200 a month, they either have to give that extra money to Medicaid in order to continue to qualify for benefits, or they can put that extra $300 into a first party supplemental needs trust and be able to use the assets from that trust for their own benefits. So I don't think I have to tell you that someone that only is allowed $900 a month for their own basic needs, by giving them an extra $300, it might change their life. So if you know someone who's disabled and they're paying a spend down to Medicaid, and we can utilize this type of a trust, it's huge for them. The third party supplemental needs trust is a trust that is funded with someone else other than the disabled individual's money. That it's funded by someone else's money. So my gentleman that I take care of, his type of trust is a first party trust. But if I create a will or a supplemental needs trust in my will for my disabled son, that is considered to be a third party trust. And that is because that trust is not being funded with my disabled son's money, it's being funded with my money. So that's a different type of trust. And the big difference between the two trusts is that with the first party trust, at the end of the beneficiary's life, any money that was paid for Medicaid or Social Security for government benefits, that money has to be paid back to Medicaid before beneficiaries get anything. It's called a payback trust. The third-party supplemental needs trust, because it was not funded with the disabled individual's money, then if that disabled individual passes away and there's money still remaining in the trust, then that money goes to whatever beneficiaries I've designated in that trust. So the difference is either pay back to Medicaid or the money gets to travel on to the grantor's beneficiaries. But this is a very important planning tool that we use, that we use a lot. It can be created during life as a standalone supplemental needs trust, or created at death under a last will and testament, or under another trust. We have lots of flexibility. So a couple other.
Okay, Judy, we have a quick general question.
Okay,
And I'm not sure if you can answer this here on the webinar, but we can certainly do a reach out afterwards. But so the general question is, they hear a lot of references to New York in this presentation. How much of this is applicable to Florida? Is it drastically different between the two states?
It actually, I would not say drastically different, but there are some key differences. When I have clients in Florida, the probate process in Florida has been a hassle for a long time. So a lot of people in Florida have trusts, either irrevocable or revocable trusts. But one of the big differences, they have very strong homestead rules in Florida, so the trusts are created a little bit different. Of course, their estate tax rules are different in Florida, where we have estate tax here in New York for if your assets are more than $6 million roughly. Those, so the trusts are drafted a little bit differently, and it just depends on whether or not the individual is a Florida resident or a New York resident. And we take all those things into consideration when we're looking at what we're the planning that we're doing for that particular person. But I'm not personally licensed in Florida, but I have several members of my group that are. So we will frequently handle matters for clients that are Florida residents, so there's no problem. There's no problem doing that. And we actually have. I mean, my firm has across the state we have 11 offices. And we have about 200 attorneys overall. We're about 25 attorneys in our Buffalo office, but we have attorneys that are licensed all over the country in our firm. So if I just did a will for a client that lived in Colorado, was a resident of Colorado, and because I had done his father's estate planning, so we took care of him in Colorado because I had someone that was licensed there. So it just depends on the situation. All right, so moving on to different types of trusts. We talked a little bit already about credit shelter or disclaimer trusts. Those are the tax planning trusts. That is useful. I know that I had already mentioned a couple of times that $6 million number, which is the amount of assets that you can pass to beneficiaries without any type of New York State estate tax. But you have to think in terms, if you're a married couple in New York, you want to think in terms of your overall estate for both spouses, because just generally speaking, how it works is that if you have a will that says I leave everything to my spouse, and each one of us has that $6 million exemption. If the first spouse dies and all the assets go to the surviving spouse, the exemption that belonged to the spouse that died, that exemption dies with them if you don't use it. So you have to incorporate a particular kind of trust in your will so that you can utilize that exemption and it is not lost. And by doing that, you are able to transfer $12 million roughly to your beneficiaries New York State estate tax free. It's a little bit easier on the federal level because they don't require, you don't lose that exemption if you don't lose that exemption if you don't use it when the first spouse dies. But if you are a high wealth individual, that's something that we should definitely talk about, because I don't want anybody to ever pay any more tax to New York than is absolutely necessary. Generation skipping we talked about a little bit already, so I'm going to skip over that. Irrevocable life insurance trust is also a trust for my higher wealth folks. I just did an estate plan where the person, my client was a real estate developer, and his almost entire portfolio is real estate, and he had a taxable estate. So what we talked about is having liquidity to pay the estate tax that we anticipate by using life insurance. And what we don't want to do is if we don't put life insurance into an irrevocable life insurance trust, then it's just going to compound his problem. It's just going to increase and inflate the value of his estate, and now he's just got more estate tax due. But by planning with an irrevocable life insurance trust, what we do is we put the life insurance into this type of a trust, and then it's locked down and it's not added to the taxable estate. So the life insurance proceeds are available to pay the estate tax that we anticipate, and that way we are able to get as much money as possible to the beneficiaries without adding more estate tax. Crummy trusts are trusts that we use. It's basically is an education trust. I did one not too long ago for a client that wanted to be able to put money annually into a trust for the education of his grandchildren and great grandchildren, and this allows us to use gift tax exemptions so that we can decrease the value of the client's estate by using exemptions that we get for $16,000 per person per year. You can give away without having to tell the IRS about it. But when you put that $16,000 into a crummy trust, that completes the, I don't want to get too technical, but that completes the gift, so that we make use of those gift tax exemptions. But it works well for an education trust. A Q-tip trust is something that we use when we have blended families, that second marriages, and the spouses want to provide for each other during their lifetime. So assets go into the trust at the death of the first spouse. Surviving spouse gets the income and maybe some distributions from that trust during their lifetime. And then at the end of that second spouse's life, then the balance goes to the children. And what this does is it locks down the distribution plan for the individuals. Because if you have a will that says, I leave everything to my spouse and I trust them to give the money to my, to my children or their stepchildren at the end of their life, they have every right to do a new will and leave everything to the mailman if they want to. So, things happen with families over very little things. And this type of a trust is something that we use to make sure that those wishes are carried out. Charitable remainder trusts are trusts that we can use to get current income tax deductions and leaving money to charities, and that is another planning tool that's important if you have charitable inclinations. So, almost done. Who should have a trust? So let's back up a second. When you're looking at your own situation, what are good reasons to have a trust? So if you're concerned about the cost of long-term care and you want to protect assets, an irrevocable asset protection trust is a really wonderful planning tool. This is a substitute now. We used to do life estate deeds for property. There are tax reasons why we do not do those anymore. So I always use a asset protection trust for transferring property. Gives the grantor a lot more control over the transaction for their lifetime. If you want to sell the house, you can do that. You don't lose your tax exemptions. If you potentially have a complex probate estate or expect a will contest, a trust is a great reason. I've had clients that were single, they were an only child, and they were elderly clients where their probate estate was potentially extremely complicated because you're having to involve family members in that proceeding that maybe that person doesn't even know or hasn't had any contact with for years and years. These are situations where having a trust in place so that you do not have an estate that's going to go through probate is so important. Privacy is an important reason to have a trust. Everything is kept private if it does not go through surrogate's court, so that you can keep everything under the radar. Simplifying the probate process for your loved ones. I have people that are not concerned with asset protection. In fact, I'm doing a trust for someone a revocable trust for someone right now who has long-term care insurance. They have very good long-term care insurance policies, and they do not have a concern about the cost of long-term care or asset protection. But the only asset that they had left in their name was their house. Everything else was under beneficiary designation, but we just still had the house there. So we're creating a revocable trust, moving the property into a revocable trust, and that way they will not have any probate, and everything will be super simple. If you have a taxable estate, we just talked about the trusts that are important to decrease estate tax liability. If you have special stipulations, if you want to set out rules for distributions, such as you can have this distribution if you graduate college, then a trust is an important thing for you to have. I also wanted to throw in, which I should have put on the type of trust list, is a pet trust, and I've actually done a lot of pet trusts lately. Mike from Level was just telling me that he got a new, very cute German Shepherd puppy. And I told him that I thought that the German Shepherd puppy should have been a part of the presentation because that would have made everybody very happy. So maybe he'll have to introduce him to us some other time. But I just did a pet trust for a parrot. And who knew that parrots have, actually I learned this, parrots have a life expectancy of 70 years. So I did a trust for the parrot that that set out a distribution for the bird sanctuary that this pet was going to go to, because we had to show that we had made financial considerations for this parrot throughout its life expectancy in order for this bird sanctuary to accept the parrot to their place. So I've done horse trusts. I did Coco the horse has their own trust, and I've done many trusts for our dogs and our cats. So that's another cool thing that we do with trusts. All of this is about you. All of this is about your story. All of your puzzle pieces and how they fit together. Everybody is unique and no one is the same. That's why I think what I do is really cool. Every one of my clients is different. Everyone has their things going on in their lives, and I get to help try and pull all this together so that at the end of the day, your wishes are, estate planning is about carrying out people's wishes at the end of their lives and how they want their money to be distributed to their to their beneficiaries, accomplishing whatever goals you have for your life in your own unique situation. But your team is so important, and in talking to your team about how a trust might fit in with you, might be might be the answer. You might do, I had people that have delayed doing their planning because they just think that there are no options. This is too hard. But talk to your estate planning attorney, talk to your financial advisors at level, talk to your tax professional. We didn't really have time to talk about taxes too much in this program because there's so much more to talk about, but these people are your trusted advisors. They have your back, and we all very frequently work together to get to the finish line. So we are at the finish line. It is 7:03. I'm sorry. Well, I think we started at 6:03, so we are exactly at an hour. And I am starting to get hoarse. So.
All right. Well, Judy, I just want to thank you so much. And if you want to advance that slide, there is Judy's contact information, but also we're at level, we're really, we want to facilitate the conversation. You can certainly text the word trust to 716-727-5047. You'll get a little auto response there. We get the message and we'll make sure that Judy reaches out to you. Until next time, I just want to thank Judy. Thank you so much. Great presentation, lots of information there. And I just want to thank everybody for attending. We'll make sure that the recorded version of this gets out to you in the next 48 hours. And until then, everybody have a great night. Thank you.
Have a great night, everyone. Thank you so much.